3 on the basis of his pending appeal before the Supreme Court. The committee notes that there is a letter from Registrar of the Kenya Supreme Court, the Supreme Court of Kenya, dated 8th June 2022, which has been admitted was served on the respondent on the said 8th June 2022. As we stated in the Samboja case, Supra, that we, under quote, agree that it is part of the Commission's mandate to consider the documents produced before it during nomination and make a decision on the basis of those documents as to the qualification of an aspirant. In the present complaint, it can be seen from the referred letter of 8th June 2022 that indeed there is an appeal. However, there is an appeal, pending at the Supreme Court of Kenya. This letter was not produced before the respondent on 7th June 2022 by 4 p.m. for the same to be considered in the clearance process of the complaint. We disagree with the complainant's submission that once presented with the document, the respondent was duty-bound under Article 47 of the Constitution to take a step and investigate whether those documents were authentic. In the case of Ethics and Anti-Corruption Commission versus Granton Graham Samboja and another, Kenyatta University and another, interested parties, 2021, petition 389 of 2017, in which the integrity and educational qualification of first respondent governor Granton Samboja was in question, the High Court stated on the question of Iebc to conduct investigations on documents presented to it as follows. The second respondent, Iebc, mandate is specifically enshrined in the Constitution under Article 88 of the Constitution 2010, which includes the conducting or supervising referenda and elections to any elective body or office established by the Constitution or other laws. The Constitution mandate of the Iebc, it appears, does not include authenticating academic certificates. It therefore follows the second respondent, Iebc, lacks power to investigate and or determine the validity or otherwise of the certificates presented by the intending candidates as long as, on the face of it, the candidate presents a prima facie valid document. Therefore, we do not find fault in the respondent's decision on 7th June 2022. The consideration by the committee of and or the interaction between Article 75 and 193 of the Constitution 2010 is unnecessary. The court in Samboja Supra went on the to state in conclusion that, and I quote, the Commission's mandate does not extend to undertaking inquiries into the validity and legitimacy of academic certificates and credentials supplied to it by various candidates, but merely acts in trust on the face value of the document, and that the impeachment of integrity of an aspirant must be on account of an order of the court or quasi-judicial body. The committee relies on the above case and finds that the respondent was under no obligation at all to investigate the documents presented before her. The burden of confirming and proving the existence of documents and facts that they needed to rely on for clearance was squarely on the complainant. we have taken note of the fact that the Samboja case above was not decided on merit since the court found itself without jurisdiction. However, we remain convinced that the conclusions made by the court on this issue are at the very least persuasive, if not binding, on this committee. Before we leave the issue of Article 75 of the Constitution, we think it is important to address an issue that came up during the hearing, where the complainant accused the respondent of having treated him unfairly and with bias. To justify his position, counsel for the complainant pointed out to the committee that Governor Ferdinand Waititu was cleared to run for the gubernatorial seat in Kiambu County after his impeachment as the governor of the same county. According to counsel, during that time, Honorable Waititu's case challenging his impeachment was still pending in court. This position was opposed by the respondent's advocate, who stated that the said Ferdinand Waititu was not clear to run. Rather, the Gazette notice referred to by counsel is not a clearance but an intent to participate in an election. This position was not controverted, and we see no reason to go further. Finally, we rely on the word of the High Court in Protas Waswa Wafula versus Independent Electoral and Boundaries Commission. The court stated as follows: any person seeking clearance, either as a party member or as an independent candidate, must satisfy as of necessity all the requisite constitutional and statutory requirements. He must also satisfy the provisions in the applicable regulations. This is because the electoral process is grounded on the Constitution and the law and regulations enacted to give effect to the said process. Such regulations aim at ensuring a smooth and credible process. Non-compliance with any of the requirements leads to disqualification. Accordingly, it is incumbent upon persons seeking nomination to familiarize themselves with all the constitutional and statutory requirements and also the applicable regulations governing the process to avoid inevitable rejection of their nomination papers. The court notes further that I am persuaded that the disqualification was premised on valid grounds, premised on the constitutional and statutory provision, and also the applicable regulations. I reiterate that it is incumbent upon persons seeking nomination to not only comply with the constitutional and statutory requirements, but also to adhere to the set guidelines and regulations, including observing time frames and submitting the prescribed documents completed as required. Guided by the provisions of the law and the authorities cited above, we arrive at the conclusion that the complainant has not given compelling reasons why we should disturb the decision of the respondent declining to clear him, since he fell short of the mandatory requirements as provided for under the law.
Okay. So, in relation to this particular complaint, in the premise, the committee finds and holds as follows: that the complaint the complaint lacks merit and is hereby dismissed. The committee upholds the decision of the returning officer, Mombasa County, rejecting the nomination application by the complainant to run for the position of Governor, Mombasa County. There shall be no orders as to costs.
Much obliged, Your Honor. We are grateful for the patience in listening to us. Albeit with a fixed mind as our flag and a political persecution, even in the hands of this tribunal, extended from the chairman himself, and we expected more justice in this particular commission. And for that matter, we do request that immediately we be given a copy of the judgment so that we may proceed to the High Court as you have made for us very salient grounds for appeal.
Okay.
From the decision that you point.
Okay.
It's a pity that this country is actually placed in the hands of a system that is so